and that they be permitted to examine witnesses as permitted by Rule 913. The court has asked the prosecution to make submissions both on their inclusion in this proceeding and in later proceedings in the future. That was established in the question 97 of the supplementary facts, that they should make submissions about future inclusion. The prosecution is happy to include them in the future. In conclusion,
before you conclude,
yes. Before what?
Before conclusion.
Before you conclude,
Yes. 2 points, one from my brother and one from me.
one is that to qualify as victims, these individuals must have suffered harm. Since genocide has not been committed, have they suffered harm, if any, if at all, what harm?
Your Honor, they have indeed suffered harm. Lubanga from, I believe it was January 29th, found that harm includes emotional suffering and mental harm. Now, in Akayisu, victim Yu was found to have suffered harm when Jean-Paul Akayisu had threatened to kill her husband and her child. These murders never actually took place, but victim Yu was included based on the emotional harm arising out of her fear. These victims have emotional harm arising out of fear, just like victim Yu, and should be included.
And what you're contending is that they have suffered mental or psychological harm.
Precisely, Your Honor.
I should have asked you this question at the beginning. I'm sorry I didn't. Assuming that the pretrial chambers declined to grant authorization, here they did, but assuming it didn't, what option, if any, was left open to the prosecution, other than filing appeal? Any other option?
With regards to?
Assuming that the pretrial chambers did not grant authorization.
For the inclusion of victims, or for
No,
the
no,
warrant?
I'm not on victims. Sorry.
Okay.
Right from the beginning, because he went to the pretrial chambers, the prosecutor, he or she, to get authorization to start an investigation. Now, assuming that the pretrial chambers did not authorize to him or her to start investigation, what options, other than going on appeal, did the prosecutor have any other option?
Well, the other ways an investigation can be commenced is if it's referred by a state party, and a state party in the region could have referred this case to the prosecutor for opening an investigation, and alternatively it could have been referred by way of United Nations Security Council resolution. Does that answer your question?
No. The answer would appear in Article 15.5. The refusal by the pretrial chamber shall not preclude the presentation of a subsequent request by the prosecutor based on new facts. And just final one, is there a situation has such a similar situation arisen lately where the prosecution went to the pretrial chamber and did not get authorization? Do you know?
I'm sorry, I'm not aware, Your Honor, but I can look through my notes and make a
Very,
submission.
very recently, that was in the Abuganda case, and my sister was one of the judges.
All right, well, to conclude, I request the court confirm the charges, include the victims, and include the testimony of Ms. Phoenix. Barring any further questions, those are my submissions. Thank you, Your Honor.
Thank you, Christine. That is like indeed for your presentation. Ready?
Whenever you're ready, Your Honor.
Can you introduce yourself and get started?
May it please the court. My name is Thomas Moskal, and I represent the defendant in this case, President Robert Chark, sitting head of the sovereign state of Empire, a non-party to the Rome Treaty, and he has been charged with inciting others to commit genocide, the most serious crime under international law. In accordance with the agenda set forth by this pretrial chamber, the defense has 4 submissions to make today. First and foremost, this court lacks jurisdiction to hear this case. Second, the arrest and surrender request issued by this court was an unlawful violation of Article 98 of the Rome Statute. Third, the Rome Statute does not allow this court to compel Miranda Phoenix to appear before this court against her will. And lastly, the applicants K1 through 34 should not be granted victim status at this juncture. Turning to the first point on the agenda, Your Honors. The defense submits that Article 12, entitled The Preconditions to the Exercise of Jurisdiction, has not been met in this case. It requires that the conduct in question occurred on a party occurred on a territory of a state that is a party to the statute. Here, the conduct in question that is attributed to President Turk is not the publication of the interview, but merely the giving of the interview. President Turk had no control, neither direct nor indirect, over how the interview would be published, when it would be published, the final format of the interview, the wording of the interview, and most importantly, the headline of the interview that states, "Emden President calls for destruction of Tupac." This was completely under the control of the executives of the Taunton Daily and star reporter Miranda Phoenix, and these actions cannot be attributed to President Turk.
Isn't it assumed that when anything is published in the newspaper, it will ultimately be published? Is it just going to be buried there and not published?
Your Honor, whether or not it can be assumed that it would be published, the fact is that President Turk had no control over the final version of the article, and 11 months he has been incarcerated, and this article has still not been substantiated. We do not know if this article is credible or if it has not been verified, and the burden is on the prosecution to provide such evidence, and no additional evidence besides the mere article has been given to the defense.
Does he deny having given this interview?
Article 67 gives President Turk the right to remain silent without that affecting the finding of guilt in this court, and the onus is on the prosecution to prove this case without the help of President Turk. We make no concessions regarding that. Additionally, the commentaries of the Rome Statute show that the drafters intended Article 12 to be strictly construed. The jurisdictional reach of this court over non-parties was one of the highest sources of debate at the Rome Conference. And the language of Article 12 was the product of multiple rounds of negotiations, and the language was meticulously selected. And we see that Article 12 was meant to give this court very limited jurisdiction over non-nationals, as we see that universal jurisdiction was brought up at the negotiations of the Rome Treaty and was immediately taken off the negotiation tables, that the parties would not agree to such jurisdiction. And the final version of Article 12 was reduced even further, as passive personality jurisdiction was taken off the table, and jurisdiction of the custodial state also does not grant this court jurisdiction. This court must find, and the prosecution must prove, that President Turk was physically present on a state territory. The prosecution is asking this court to apply a narrow extension of the effects doctrine, but in reality, the prosecution is really asking this court to broadly interpret Article 12, and this goes against the intentions of the drafters. The effects jurisdiction for the Special Court of Sierra Leone was explicitly granted in the statute that governed that court. It is not explicitly granted in this statute. If the drafters had intended so, they would have included effects jurisdiction. If there are no further questions to jurisdiction, Your Honors, we'll move to the second point on the agenda. The legality of the arrest and ensuing detention of President Turk. The defense submits that this court violated Article 98 in issuing the arrest and surrender request without first acquiring a waiver of immunity from the state of Empire. The defense feels that this is a blatant violation, and very clear. And the prosecution says that the arrest was required under international law, but also a waiver of immunity is required by Article 98 of the Rome Statute. Your Honor brought forth the question earlier that there is tension between Article 27 and Article 98 of the Rome Statute, and the defense agrees. But we believe that these two articles are reconcilable. Article 27 deals with